This is my mom's letter concerning Bill and his behavior towards her. Another observation about his character. I filed for divorce in November 1987. The papers were filed in December 1987. Bill's response to this was to lock me out of the apartment and not let me have Bethany's or my things. He also told me that he would take me to court until he broke me, physically, mentally, emotionally, and financially. He was allowed to visit any time he desired. He generally just arrived without forewarning. He also generally came after Bethany was asleep. I told him he had to let us know when he was coming. His response was to take me to court, asking the court to award him permanent custody. 1. In court, we made an agreement as to date and time when I could get Bethany's and my things. He then called me 2 hours before this set time and told me he couldn't come. I reminded him that he was the one who chose the date and time, so let's just do it. When I arrived, he had the police there. He would let me have nothing and opened cabinets, etc., for the police officer and I to see inside. He refused to allow me to even take Bethany's things. We were also told in court to make visitation schedules that could be used to try to work towards standard visitation by the time she was 2 years old. I submitted mine and he never submitted one. I then started visitation according to my schedule and said we would use that until he came up with a proposal. Rather than talk about the schedule, his response was to again take me to court. This time his complaint was that I wrongfully denied him visitation and refused him overnight visitation. Bill still submitted no schedule to the court, but was granted Monday, Wednesday, and Friday during the days for visitation from 9 o'clock a.m. to 5 p.m. Child support was also reduced since Bill said that he was unemployed and was trying to start a business of his own. Bill also requested that he be granted the truck for his use. This referee said that each party was to use the vehicle they had been using prior to the daycare personnel. Hang on. And I informed them that there was nothing... Wait a minute. This referee said that each party was to use the vehicle they had been using prior to the daycare personnel, it looks like. And I informed them that there was nothing I could do. It was a court order. Shortly after my discussion with the daycare personnel about 6/1/88, all-day visits ceased. Bill then approached me saying he needed more time with Bethany. I asked why 3 days a week weren't enough. He said he was looking for a job and needed some time in the evenings as well as daytime hours. I said that I would make an arrangement for 3 weeks until the end of June. I then asked him to talk to me about his progress at the end of that time. I gave him extra hours on Monday, Wednesday, and Friday nights, as well as his daytime hours, and Saturday mornings. It should be known that there was a court order stating that he was to inform the court if he were to become reemployed. I heard nothing from him about his progress in finding a job. He used both daytime and nighttime hours for 3 weeks. At the end of 3 weeks, I informed him that I had no time with Bethany, and since he had not found a job, yet was still able to visit during the daytime, that he could still have daytime hours, as the court order stated, until he found a job. The next Tuesday, during the daytime, he repossessed the truck while I was working. Just before taking the truck, he made sure that I paid the insurance on it. He verified that I paid the insurance on Friday before he took the truck. He took the truck the next Tuesday. He missed the Monday holiday with Bethany from 9 a.m. to 5 p.m. as the court order allowed. He used the daytime hours to visit one more time after that. He picked her up at 8 a.m. against the court order late in July. He tried to avoid my knowing that he picked her up at this time. I happened to see him take her as I was going to work. I asked the daycare about this. They said that they had verified it with him already. I got the impression that they had the feeling he'd confirmed this with me. I asked them if they had given her breakfast that morning. They said they didn't have time in the 5 minutes. They thought that I might have given her breakfast. I informed them that since I didn't know that he was picking her up before the court order allowed, there was no need to give her breakfast that morning. I believe that Mary Pat Burke, who was doing the custody investigation, was coming to his home that day because she had informed me the week before that she was unable to do an unannounced visit to his home. he still had not come to me to say he needed a permanent change of schedule and that he was employed. Instead, he took me to court again, saying, "The parties have tried to work this matter out directly, but the plaintiff has willfully refused to provide the defendant with adequate visitation." 3. The report of the referee states that the parties had made up a voluntary visitation schedule, but wife is alleged to have reduced visitation significantly after husband removed the marital truck from her. This is what Bill testified, but I never got a chance to say anything about what really happened at this hearing. In court, the referee asked Bill when he started working at Architects Plus. He stated that it was sometime in July. When pushed on this, he still indicated he didn't know when he had started, but that it must have been about the middle of July. Also, the referee states that the agreement that the parties had voluntarily worked out previously involved visitation on Tuesday and Thursday evenings, along with visitation on Saturday mornings. Since I did not testify to this, she had no idea that it was Monday, Wednesday, and Friday evenings. Bill had testified that it was Tuesday and Thursday evenings. The truck was awarded to Bill, and she stated that father shall make her car roadworthy at his own expense, including fixing the seats and or adjusting the pedals so that mother can reach them. She also stated that mother is precluded from filing a motion for contempt for father's failure to notify the court or her of his new employment. Visitation was posted for all day on Mondays and Wednesdays. It stated that father may pick up child up from daycare on those days between the hours of 9 a.m. and 11 a.m. or, alternatively, between 3 p.m. and 5 p.m. It was stated, although not written, in court that he could not pick her up during these hours. I should drop her off at Architects Plus after work. It's obvious this must have been what was said, since it can easily be verified that I did drop her off at Architects Plus during this time. Also, the referee had stated that he had a choice of Saturday morning visitation or Saturday afternoon visitation. It was not well written in the report. The referee states, additionally, father shall have visitation on Saturdays beginning at 9 a.m. and ending at 1 p.m. If father so desires, he may pick up the child at 1 p.m. on Saturdays and return her at 5 p.m., in addition to the morning visitation. It should be obvious that if the visitation ended at 1 p.m., that it doesn't then again start at 1 p.m. I knew that Bill would pick up on this problem with the report and try to use it, so I filed an objection to the report of referee. Bill did pick up on this and tried to use it, saying that I was refusing him visitation. The police were again called. He was also ordered to deliver me a safe vehicle for transportation with a bill of repairs within 30 days. After 30 days, the car was still not delivered. He brought it just before the next court date with the police. He had no bill of repairs, and when requested, gave us a bill of repairs with the name crossed out, as well as the prices and what repairs were effected. During this time, it became more apparent that something was amiss. Bethany came home during the drought, having had nothing to eat or drink. There were times when she came back with burns on the back of her arms, and a rug burn on her chin, a pinch on her arm, and vaginal infections. She had not had vaginal infection prior to this time, and has not had one since this time. I was also getting complaints from childcare, and they said they were going to call 241 Kids. She also became very resistant to car seats. We hired a detective and had him followed. The detective verified that he had started his job on 6/1/88, and that he seemed to just ride her around in the car. This brought us up to the hearing in front of Judge Beckwith. To date, I still had none of Bethany's things, and she had grown out of her portable crib, so I rented a baby bed from a friend in the interim. 4. On the day of the hearing, Bill found out we had hired a detective, and that I had witnesses to disprove a lot of what he said and did. He became anxious and was purported by one of my witnesses to be crying around the corner. He indicated he would sign anything rather than have it known that Bethany had vaginal infections while under his care. It was suggested that visitation be supervised, and he readily agreed to it. It was then ordered that we go to the court counselors for determination of visitation arrangements. I informed the court that I could not make the first date that was arranged. I later found out I'm not allowed to cancel an appointment. Only my lawyer could. When we went to one session together, at this time, Bill said to me that this game is very exciting. I asked him what game he was talking about. He said who was going to win Bethany. I informed him it wasn't a game. I don't think any of the counselors heard this statement. He then missed the next appointment and indicated not being able to reschedule for another time. Since I already missed 3 days of work, Miss Linhart suggested that we find a counselor or mediator out of the court system, where evening hours could be easier to schedule around. 5. The next hearing was for a reduction of child support. Since he was again unemployed, it was granted. The child support remained at this level until I filed to increase it in 1993. He has never told the court when he has become re-employed, in direct violation of the court order. Just before the next court date, Bill brought out Bethany's bed. He said he didn't want to pay storage costs on it anymore. He also brought out a few of her clothes I had asked for the year before. Needless to say, the difference in size between an infant of 9 months and an infant of 23 months is considerable. Bethany couldn't use the clothes. 6. At the court date for the property division, things had been sold, stolen, etc., in direct violation of the referee's order. Bill also told me that it was a figment of my imagination that we ever owned certain higher-priced items. He also used the highest amount balance I ever had in my bank. This was joining of mine and Bethany's accounts from Columbus when I moved down to Cincinnati. Yet all of his accounts were not even listed. It was not worth arguing. I knew I would get nothing anyway. Bill said that the things that were marked with an S were in storage. I was told by his lawyer to take everything in storage to cover the balance of what he owed me. My parents thought he might try to remove the items from the storage bin, so they brought the court order down to Stronghold Securities. They placed their lock on the storage bin that day. That night, Bill had apparently tried to get into the storage bins, but was unable to. He refused to let me come and get the property. 7. At the court date for the divorce decree, Bill requested that I be required to pay for all of the storage costs for June, saying that I refused to allow him to get his property. He then refused to sign the divorce decree on the possibility that if I did not have insurance for Bethany covered through my place of employment, he might have to share the costs for insurance or medical fees. My lawyer was told to rewrite the divorce decree in a way that Bill would sign it. 8. We came again for the final decree, and Bill refused to sign it. The judge said she would grant the divorce whether he signed it or not. After telling him that he would be detained unless he signed the decree, Bill agreed to sign it. It was recommended that we go to mediation to determine the issues at hand and work through them. 9. Bill walked out of the first mediation sessions with Carol Brandt, stating that he would not return. It was a waste of time. He then took me to court for retrieval of storage costs from Stronghold Securities and asked for standard visitation. He refused to pay the extra storage costs incurred for June, after he refused to let me have any property in May of 1989. Since he did not get a judgment to have me pay on the storage costs in the final decree, he refused to pay Stronghold. Stronghold Securities then contacted me stating that if the fees for the storage were not paid at all for 90 days, they sell the items at auction. They asked if I would like to come and claim some items before they auctioned the rest if Bill did not pay them by late August. Bill did pay them the storage fee by the last possible date, and I was allowed to recover some of the items marked with an S. I didn't get everything, but I knew it was all I was going to get, so I let it go. When it came to court, the referee stated she was not taking testimony about storage because it was in the wrong court. She also recommended that psychologicals be done after Bill became evidently angered in court. The referee's report indicated that there was no testimony as to why Father's locks were cut or replaced. There was no testimony as to why Father had to continue paying on the storage. Of course there wasn't any testimony given. Bill stated these things to her, and she indicated that he was in the wrong court. Bill objected to her report, and the objections were heard in front of Judge Gaines in early 1990. Previous to this, we went to Joe Beeler for court-conducted psychologicals. 10. Bill's objections to the report of referee were heard and overturned. 11. Bill took my mother and Stronghold Securities to court. My mother asked to leave since she was not actually a party involved in the contract. Stronghold Securities won the case, except for the reimbursement of the cost of Bill's locks, which they had cut from his storage bins. Where is the motion for 1990 as the last part on this? Obviously, Bill was irresponsible in this. Obviously, he harassed Stronghold Securities, did not cooperate with visitation schedules, did not cooperate with financial issues, did not cooperate with getting my things, did not take good care of me, etc., 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 etc. If nothing else, it shows extreme irresponsibility and dishonesty. Okay, Miss Farmer, this letter was written by. I presume that means my grandmother, since it looks like it's in her writing. Saturday, November 7th, 1992. Bill showed up with Lynn at about 9:20. He wanted, he said, to go out with Bethany. Peg said she was going along. Bill said they would go out for breakfast, and then he and Lynn would go on and then end the visitation. We all went to Frisch's, and Bill got Bethany breakfast, and he and Lynn had coffee. At 11:10 they left. While at Frisch's, Bethany made a drawing on a napkin, and Bill said he would take it home. Bethany said she would decide between Bill and Mommy. Peggy said nothing. Then Bethany played Eeny, Meeny, Miny, Moe, and said that Peg won, so she gave the drawing to Peg. While at the house, when Bill first arrived, Peg and Bill were discussing the visitation, Bill claiming that Lynn was an approved supervisor, Peg claiming an objection had been filed. Bill did not look at Peg when he was talking to her. He looked at me, although I was reading the newspaper and not involved in the conversation at all. Whenever I looked up, he was looking at me. This is the standard procedure. He will not look at Peg to talk to her. He often talks to Peg through Bethany. More. Incredibly, there's more. Lots more. I believe this one is written by my grandmother or my grandfather. I'm not entirely sure. But these are behaviors observed. 1. When Peg left Bill, he said he wanted Bethany to be with him one night, and Peg one night. Peg said Bethany should have stable arrangements and would bring Bethany to his apartment until time for bed, then take her home. He said no. She is 50% of my property, and I have a right to her 50% of the time. 2. Bill was, at the beginning of 1988 or 89, I can't read this very well, Bill was permitted to see Bethany whenever he chose, but he usually came after Bethany was either in bed or getting ready. Many times I would heat the leftovers for him for his dinner, so I know he arrived late. 3. For 2 of the years, from 1988 to 1990, when he had visitation on Tuesdays and Thursdays and Saturdays, he never came on Tuesdays or Thursdays. Peg would bring Bethany for visitations, and he would not come, nor call, and no explanation. And when he came on Saturday, he never mentioned missing Tuesday or Thursday. Oddly enough, during April 1989, when Peg was gone on vacation, he showed up on these days and brought the police. Part of the time he lived in this area and later moved out to Hillsborough. 4. In 1991, he called Bethany ugly, and it was not said kiddingly. She later cut the front of her hair to look prettier. Her babysitter had cut her hair and he didn't like it. 5. When he was here to visit downstairs in the family room, Bethany would often come up to the living room and climb in our laps and suck her thumb. Later after, she claimed he touched her, and she told me that he shouldn't have made her go back. We shouldn't have made her go back down to him. 6. He said in front of Bethany that he wouldn't pay a penny to visit with her, his daughter. If Peg hadn't paid the full cost, $140 for visitation during December 1992, he wouldn't have seen her. 7. Showing up at the door, shouting at the door about taking our house really upset her, and she worried about her grandparents. That was me. I heard that. Bill threatened to kick everyone out of the house as homeless beggars. 8. Many times when Bethany would refuse to visit, he said he would have Peggy put in jail. Always this is said in front of Bethany. 9. There were many times when Bill, Lynn, and the supervisor would try to coerce Bethany to visit. Once they were downstairs in the family room from 9 to 12. The supervisor came up and asked the time. She said, "We've been after that child for 3 hours. That's child abuse." 10. When they had supervisors, Peg and Bill rotated getting them. Peg always contacted and made arrangements months in advance. Bill often waited until the last minute and often did not get one. One supervisor testified that when she came to work on Monday, there would be a message that Bill left on Friday after she left. If he wanted so much to see his daughter, why didn't he make arrangements early like Peg? 11. When he couldn't get a supervisor, he many times came anyway without a valid supervisor and then called the police on Peg in front of Bethany. 12. Once Ed, my grandfather, and I, that's my grandmother, had to drive Peg to McDonald's for the visit, and Bill did not have a supervisor. Peg invited him to talk to Bethany and verify that she chose not to visit. He came out and held the back door open where Bethany was sitting. She asked him very politely to close the door and let her alone. She even got out of the car and tried to push him away from the door. Failing that, she got back in and tried to get him to shut the door. Peg finally went to call the police and he left to the car. Bethany told us on the way home that her stomach feels funny when she has to come on visits to see him, and she wants to barf. The really traumatic part of this was that she tried to shut the door, and he held it open, and that made her upset. 13. There were many times that Bethany did not want to go out, but asked him to come in, and he refused. Then he told her that Peg was keeping her from him. Since Peg offered him to come in, Bethany knew this was not true. She told Fisher, the psychologist who was hired by Bill later, who was really nasty, that her mom doesn't care if she goes out. Bethany doesn't want something about this on tape. This is on tape. Bethany doesn't want to. This is on tape. 14. Hiding Lynn in the back of the truck and leaving her off at his parents' driveway was deceiving to Bethany, and when she confronted his mother about his living there, it was as if he had lied to her. 15. She says he touched her. When he tried to say it was the time he claimed she jumped off in his arms, she said it was no accident. Rubbing herself in the vaginal area, she said, "This is no accident." She also said he put his finger in her mouth, and she tried to push it out. No one ever explained about this, nor claimed an accident. This also was told to Fisher and is on tape. 16. On April 1995, he forced her in the car and forced her to visit. She tried to jump out of the car and run away. She told a fisherman at the park she was being kidnapped. When the police came, he said she had to visit, and she said she was afraid of her mom going to jail, so she played. This is on tape. 17. Often when he came for visitation, he would read and even fall asleep once. Bethany said that when Bill and Joyce and they went to Forest Fair Mall. Bill and Joyce would talk, and I would ride on the rides. They hardly paid attention to her most of the time. And most of that was because of Bill. He spent most of his time distracting Joyce. Even though she was a good woman and everything, it was very hard for her to try to give me the attention that I needed when Bill was constantly pestering her and trying to convince her of all sorts of lies. when Judge Gaines sent the case to juvenile, she said Bethany would go into foster home and Bill would no longer have visitation, and he should just write her off. When Peg told Bethany, she cried and screamed about going from Peg. Bill was out in the hall and saw and heard Bethany through the glass window. Bill was in the hall laughing and high-fiving to his wife and witness. How can a father who claims to love his daughter be happy about losing all contact with her? 19. On December 1992, he came with his wife, Lynn, to visit. He had her Christmas presents. Bethany would not go, even with a supervisor. Lynn got in the car and started to drive down the driveway, and Bill and Bethany were standing in the driveway behind the car. Bethany cried, "There go my presents." Bill said she would have to go out to get them. Bethany had previously asked them to come in while she opened the presents, and he refused. Since she wanted her presents, she knew she had to go out, so she did. Another letter, I think by my grandmother too, but I'm not sure. It might be by my grandfather. Characteristics. 1. Bill asked Peg to file jointly for 1987, looks like taxes, even though she filed for divorce. Even though she would have been better off financially, she agreed and even lent him $750 to pay his taxes. He gave her a note due in a year. Instead of paying her, he asked the court to make it part of the property settlement. The referee agreed. She never did get near the amount of property due her. 2. Bill did not carry Peg or Bethany on his insurance. Peg had to stay in Columbus to have Bethany and have a double jaw surgery in the summer of 1987. When she filed for divorce and decisions were made, she was responsible for Bethany's health insurance. Bill refused to cover Bethany's and finally was shamed into paying half of all reimbursement expenses over $200. 3. In April of 1988, after she filed for divorce, Bill went to Jewish hospital and had his face sanded. He charged it to Peg's insurance without her knowledge. Eventually, she had it straightened out after much explaining. He knew he wasn't covered. See document. 4. He claims Peg married him for his money. Yet 2 days before their wedding, he asked her to sign a prenuptial agreement. She did. If there is one person who cares less about money than Peg, I don't know them. She supported herself during college, and after their marriage, she had grants to support her and her studies. When Bethany was born, she took complete responsibility for her. 5. On July 5th, 1988, Bill went to the parking lot at Children's Hospital while Peg was working and took her vehicle, truck, which she had always taken care of during their marriage. She used it while in Columbus. He called and told her that he had left the other car on the street in the area. She couldn't find the car and had to have her mother come and get them and bring them home. The next day, she found the car, but the front seat was permanently fixed, so she couldn't reach the pedals. Bill is 6.3 and Peg is 5.2. In court, the referee, of course, let him keep the truck, but he was ordered to fix the seat and make the car safe and roadworthy. He brought an invoice with no details. Peg had our mechanic check it out, and he said it was unsafe, exhaust fumes leaking into the back seat, and steering unstable. This car was the one he chose for his daughter to be transported in. See documents. He said he got new tires and gave Peg an invoice from Tire America. She got the original invoice, and the discrepancies are obvious. See documents. In fact, he used a visitation day